Leah Litman is a professor of law at the University of Michigan, a former Supreme Court clerk. I hear her nearly every week on the Strict Scrutiny podcast, a part of the Crooked Media, Pod Save America suite of podcasts. And if you listen to her there, you're probably not going to be shocked to know that she has some critiques of the U.S. Supreme Court, Alito, Thomas, and the gang, mostly the gang. They're put in a new book and juxtaposed with her thoughts on the Barbie movie, Game of Thrones, and if there's always money in the banana stand, in a new book called Lawless, how the Supreme Court runs on conservative grievance, fringe theories, and bad vibes. Leah Litman, welcome to The Gist.
Thanks so much for having me.
So I do listen to Strict Scrutiny a lot, and I actually, my media diet is to go there, then to go to Advisory Opinions, and maybe between the two of them get some synthesis about what to think about recent Supreme Court decisions. But if listeners to my show listen to your show, they wouldn't be surprised to know that there is a lot of criticism of how the court is coming to its conclusions, not even necessarily the conclusions. But what I would like to do, if you would, could you go back to the conservative justices on the court, from Whizzer White to Potter Stewart to Rehnquist, who almost almost spans these eras, and tell me why those conservative justices were, in your opinion, if they were, of a different type or a different ilk or doing something quite different from these conservative justices.
So I actually think of the ones you named, Chief Justice Rehnquist is probably most similar, and he figures pretty prominently in the book because I think he is in a lot of ways the precursor to the modern Republican appointees on the Supreme Court. Justice Rehnquist was one of the dissenters in Roe versus Wade. He was elevated to the position of Chief Justice after he dissented. He is also the author, I think, presumably, of the opinion in Bush versus Gore that had stopped the presidential count in Florida and ordered Florida to certify George Bush as the winner of the presidential election. So I think he is, in a lot of ways, a symbol or stalking horse for what the Republican appointees would become. That being said, he did not do all of the things that the modern Republican appointees are doing, but I think he is quite similar and was a sign of things to come. The earlier nominees that you were identifying are conservative nominees, but I think part of what makes them different is their views are a little bit more heterodox than the modern Republican appointees. Some of what has changed about modern Supreme Court appointments is in part because of partisan polarization, but also because of the focus on the conservative legal movement's judicial selection machine. They've been better able to identify prospective nominees who will more reliably rule in predictable ways.
Right. So in the past, you might get a Republican appointee, I don't know, David Souter, and he turns out to be a reliable left-leaning vote on the court. And Whizzer White was also one of the dissenting votes in Roe v. Wade, but he came to it, you're saying, more honestly and less as a consequence of a concerted effort beforehand to pre-craft what his jurisprudence would be?
Yes, exactly. So in the lead up to Roe, during the period in which Justice White is appointed, it's not like a political party was out there looking for Supreme Court nominees who would say that abortion isn't a constitutional right. But that doesn't describe the judicial selection machine as it has come to exist.
So there are heterodoxies among the justices now, and beyond not every decision being 6-3, or sometimes Roberts dissents in 5-4, but it's still a conservative majority decision. There are plenty of decisions where the scrambling of the justices wouldn't be predicted by the party of the president who appointed them. How to explain that within the context of your overall thesis, which is it's a different kind of conservatism, a stamping out of conservatives who will march in lockstep with a predefined ideology?
Yeah, so there are some differences among the Republican appointees on federal Indian law, Native American affairs. Justice Neil Gorsuch differs from some of his colleagues.
That's his one big thing, yeah.
That's his jam. And it turns out that Amy Coney Barrett's big jam is whether the president gets to exercise all of the power he wants and then some. So I think there are going to be some issues on which the Republican appointees differ. But my concern is that the media and commentators sometimes overemphasize those, in part because they're just more interesting. You know, from the perspective of a lawyer or a law professor, it's much more fun to talk about cases that don't have an ideological breakdown than it is to talk about the cases that do, because when they do have that breakdown, then partisanship, politics, and ideology are more of an explanatory focus than legal analysis might be. As to what explains those differences, I think the reality is the Republican Party selected some issues that were more important than others, and those were the issues on which they focused more of their energy to identify prospective nominees. Those are also the issues that they have focused more on their messaging within the conservative legal movement and that ecosystem. So on voting rights, affirmative action, abortion, LGBTQ equality, those bigger ticket issues, as well as the administrative state and the powers of regulatory agencies, those are the issues on which the Republican Party focused and continues to focus. And those are unsurprisingly the issues on which there is the ideological breakdown.
I think the media is mostly focused on the biggest issues, which are often the 6-3, sometimes 5-4 issues. And I would say that Dobbs got a lot more coverage than any of these niche issues on Indian affairs. And I would say the immunity case got a lot more coverage than any of these issues on, more ideologically scrambled decisions.
I think those two decisions definitely got a lot of attention, but if you look at end-of-term retrospectives and recaps, you will often see emphasis on, well, they didn't divide 6-3 or 5-4 in all of the cases or a supermajority of cases. Instead, look at these interesting breakdowns. And it's in those sort of retrospectives and recaps or even previews that I think the emphasis gets placed on the differences rather than similarities.
So you think it is statistically less likely or I should say it this way. If you look at the statistics of what the decisions were, 9-0 is much more common than 5-4 or 6-3. So it's not it's not outside the realm of journalistic responsibility to make that point. It's also within the journalistic responsibility to point out the times that the courts didn't march in lockstep ideologically. I think that those aren't just necessarily little asterisks. It's important for the public to know what the court is really doing and how often they do totally agree, how often there is just one dissent, and how often that one dissent, maybe surprisingly to some, is quirky and not just Alito or Thomas digging in his heels, but it can be any one of the justices.
I just think that those numerical and quantitative estimates really skew the perspective on what the Supreme Court is doing. And it's one of the criticisms of the book is that kind of descriptive way of depicting what the justices are doing can miss how the breakdown changes on the issues that affect more people's lives, the issues that have more of an ideological bent. And so, for example, if you imagine a Supreme Court term where there's 75 patent cases, one case about whether the president can deport people without due process, another case about whether marriage equality is still a thing, another case about whether women can have health care, another case about whether the Voting Rights Act is still constitutional, another case about whether administrative agencies can exist. Who cares if there are 75 9-0 cases? And I think an opinion breakdown or a term recap that says, look, there are these 75 unanimous cases, and 5-6-3 splits without breaking down the substance of those rulings, the extent to which some of them changed the law, others didn't, the extent to which some overlap with political movements and social movements, others do not, the extent to which some draw from political talking points, others do not. I think it gives the public a skewed perspective about what the justices are up to.
How do you know you're not engaged in this skewed perspective of seeing the decisions that you firmly disagree with, which, by the way, I probably do too. And I also disagree in some part with the logic and the reasoning that goes into the decisions. But how do you know you're not ascribing more importance to the really bad 6-3 decisions as opposed to looking at Masterpiece Cake Shop, right, which was a 7-2 ruling, or I think it was, what was the name of it? The Wisconsin case where 7 of the 9 justices ruled that Wisconsin voters couldn't challenge their state's legislative map. There are a whole lot, my point is, there are a whole lot of really, really important cases that aren't decided just the Republican majority.
Yeah, so a lot there.
But you think,
I mean,
I'm taking it that you essentially disagree. You think the most important cases are 6-3.
I think the most ideologically salient and the most consequential cases, yes, tend to break down along ideological lines. A few things. One is part of the criteria for what kinds of cases that I think are important are cases that change the law, cases that have the potential to transform the legal landscape and government institutions. And so the decisions that you're pointing to, Masterpiece Cake Shop and whatnot, those moved the law in smaller directions, but didn't do the kind of radical transformation that the major questions doctrine, overruling Roe, ending the Voting Rights Act, and whatnot did. So I think assessing these requires some legal context, and that's part of what I try to offer in the book, part of what we try to offer in the podcast and whatnot. So that's part of it. The second is part of the focus in the book is breaking apart the legal reasoning. And so that's also a criteria that I'm using to select the cases that I think are explained by ideology, that I think is important for people to understand. So a case like Shelby County versus Holder, for example, where the Republican justices in the majority blow up the crown jewel of the civil rights movement, the preclearance regime of the Voting Rights Act, on the basis of a totally invented constitutional principle that John Roberts invents by inserting a misleading ellipsis to change the meaning of a quote from a prior case, and a principle that fails to understand and explain the history of Reconstruction, because the rationale in that opinion is that Congress had unfairly discriminated against some states by subjecting some states, but not others, to the preclearance regime that required them to get federal permission before changing their voting laws or policies. But the reality is the Reconstruction Congress, after the Civil War, repeatedly singled out the former Confederacy and subjected them to different rules. So there's just a lot of information that I think goes into the calculus of what cases are significant. And it's that kind of coverage that I just think is basically journalistically impossible to transmit in a piece that is 1,000 words.
Yeah. So just for the record, I think the voting rights cases and the Trump cases and, of course, the Dobbs case got the most coverage by far. And some of the cases that you write about that are like Masterpiece Cake Shop, which was the one with 330 Creative. Is that the number? Am I getting that right?
Yeah, 303 Creative.
303 Creative. I got, sorry,
case,
transposing those numbers. That was extremely similar to Masterpiece Cake Shop. And I don't know why, so 303 Creative had a lot of prominence in your book because it illustrated what you were writing about. But Masterpiece Cake Shop, which wasn't 6-3, wasn't as much in your book because it didn't illustrate the point, I guess.
No, Masterpiece Cake Shop is in the book. Part of the story that I tell in chapter 2 is how the court started taking cases like Masterpiece Cake Shop and then Fulton versus City of Philadelphia and then 303 Creative in order to chip away at LGBTQ equality. And Masterpiece Cake Shop was the first case where the justices went down that road in doing so. I think Masterpiece Cake Shop actually does really illustrate the point that I am trying to convey in the book, which is that the modern Supreme Court loves to claim groups that are associated with the modern Republican Party are victims and then use that to kind of victimize historically subordinated groups. Now, I recognize that Masterpiece Cake Shop is a 7-2 decision, but part of what I caution about in the book, and that Masterpiece Cake Shop is actually related to a whole separate story I hope we can tell, is focusing just on the breakdown ignores the changes in the law and how the Democratic appointees are oftentimes under pressure to make concessions to avoid bigger rulings that will change the law in more dramatic fashion, as well as make accommodations that affect other cases. So Joan Biskupic, CNN's legal analysis, reported that Masterpiece Cake Shop was actually part of a deal with another case, Pavon versus Smith, where the Supreme Court agreed to reaffirm Obergefell versus Hodges and say that states were required to issue birth certificates to same-sex parents of children, as well as opposite-sex parents of children conceived through IVF or artificial reproductive technology. And so the justices said, yeah, we'll reaffirm Obergefell, but guess what? We also want to start creating this First Amendment exception to LGBTQ equality. And the agreement was to do so more narrowly. And so I think just pitching that as a 7-2 case that showcases the non-ideological or non-political nature of the court misses those parts of the story.
Yeah, I don't think the court's non-ideological at all. It's clearly ideological. It just doesn't always come. Well, I want to be clear and precise. It's so often the data set of how often it goes 6-3 or 5-4 and how often it goes somewhere else is not. It's a little correlative. It's far from as correlative as I think most people would agree. But I'll also concede your point that in the very biggest society-changing cases, clearly like Dobbs, that was exactly how it went. However, I would also ask you, is it the case that it is only through backwards engineering? What does the Republican Party want? How do we get justices on the court that agree with what the Republican Party want? Why is that the best way to look at how courts, which have always been ideological, why is that the best way to understand why there are now 6 votes to overturn Dobbs, as opposed to a whole lot of other reasons, which is something like there's a body of jurisprudence where the people who adhere to it naturally looked at Roe versus Wade, looked at Roe versus Wade and said this was poorly decided. And it was poorly decided, maybe even if we're sympathetic to the idea of women being allowed abortion. You know, why is the idea, I guess, in a short question is, why is it more likely that this was done to appease the Republican ideology as opposed to the genuine thoughts of judges within the legal system assessing how that landmark case was originally decided?
Yeah, so 2 things. One is, on some level, I just don't think it matters whether the judges view themselves as selecting an interpretive methodology that they think is just the best interpretive methodology, or if they are saying, I overrule Roe because I think abortion is murder. Either way, the Republican Party can select justices who will advance their political, partisan, ideological agenda. And so if that is the mechanism, either way it's happening, we should still understand the justices to be selected and appointed to advance partisan, political, ideological aims. So that's one thing. But second is, as I unpack in the book, originalism was originally sold and developed as a methodology to turn back the civil libertarianism and civil egalitarianism of the Warren Court. So Ronald Reagan's Attorney General gets up and stands up in front of the entire American Bar Association before there was this well-established conservative legal movement and conservative legal ecosystem and says, guess what? A jurisprudence of original intentions, that's the way to challenge the radical egalitarianism and radical libertarianism of the Warren Court. This is said repeatedly. Another official within the Reagan administration, Stephen Markman, who would go on to become actually a justice on the state Supreme Court where I live, Michigan Supreme Court, authored a document in which he said originalism is the way to advance the social issues, social policy of the Reagan administration. So they baked into originalism ways of advancing their preferred social policies. That's the way it was developed. That's how it was taught. That's how it's been practiced. And so I just think these things are inseparable in a lot of ways, in part because originalism is always going to lend itself to this agenda of rolling back certain rights. You know, it overlaps with this, let's make America great again, a restoration of some great past. And it is flexible and manipulable enough to allow the justices to do the things that the Republican Party is urging them to do.
Yeah, but to go to Dobbs and Roe, you don't need originalism to overturn that. Ruth Bader Ginsburg was very critical of the analysis of Roe.
Can I stop you right there? I think this is one of the absolute worst talking points and things that has been said to people about Roe. Justice Ginsburg's criticism of Roe versus Wade is that the decision focused too much on the rights of male doctors and how abortion restrictions interfered with their ability to practice medicine. She wanted the decision to be grounded in equal protection principles, to show how abortion restrictions discriminated on the basis of sex and undermine women's ability to participate equally in the workforce. And her criticism of Roe is that it was not developed as part of that equal protection litigation strategy. She refused to retire under President Obama because she didn't think any other prospective replacement would be as protective of abortion rights as she was. She is not someone who says, let's overrule Roe, Roe is wrongly decided. She wanted it to be reasoned in a different way and to reach more far than it did.
Yeah, I don't know what you think the talking point was, but basically she believed that Roe was based on the wrong argument, a violation of women's privacy rather than gender equality. We're not saying different things, but that's what the argument is. She looked at the original way Roe was argued, and she had a critique of it. But of course, this all comes back from Griswold and penumbras of emanations and finding a right to privacy in the Constitution, which you don't need any doctrine of originalism. And I know Ed Meese promulgated that, and I know that Strom Thurmond believed in originalism, but originalism never had to exist to look at Roe and find that it was a very shaky ruling. So, and the only reason I say any of this is if the entire conceit is that this is a concoction of a vast right-wing machine, and there is a vast right-wing machine, and Leonard Leo is paying for these people, but I don't think it shows up in the Roe ruling. To me, anyone, you don't have to be bought and paid for or part of the Federalist Society bench to look at Roe and to have had problems with how that was actually decided. It doesn't actually flesh out your general thesis of the vast right-wing apparatus that is warping the Supreme Court.
So I disagree for two reasons. One is that if you disagree with Roe's reasoning, that doesn't necessarily require you to overrule Roe, right?
That's
Replacing
right.
its reasoning with equal protection would actually expand the protections of Roe, not result in overruling or restricting it. Whereas coming up with this interpretive methodology like originalism, that is a justification for overruling Roe in a way that just criticizing its basis as being grounded on privacy rather than equality isn't. Second is, I think that originalism helped in a lot of ways because what it became code for is overruling Roe without having to say overruling Roe. And so that allowed the Republican Party to traffic in these ideas where people understood what they were saying without them having to explicitly own it once it became clear how wildly unpopular it was. So if you think back to, for example, Brett Kavanaugh's confirmation hearing, former Senator Ben Sasse said, look, we have had women screaming about how women are going to be dying at all of these recent confirmation hearings, and that has never happened. Let's talk about stare decisis and originalism. And that provides a vocabulary for these confirmation hearings to happen in a register that isn't about women dying, women being denied health care, but it is still the method through which the justices are going to accomplish just that. And that's how it was developed. You know, the method that Justice Alito applies in Dobbs is the one propounded by Chief Justice Rehnquist, one of the original dissenters in Roe, that he offered once on the Supreme Court after he was elevated to Chief Justice. And everyone understood at the time that opinion, Glucksberg, was trained at overruling Roe, because if you define the history and tradition originalism in that way, it will inevitably result in Roe being wrongly decided. So I think you can track the development of the movement, track the development of the law from beginning to end as pretty clearly trained on the project of overruling Roe.
Without originalism, do you think Roe wouldn't have been, without the idea of originalism, do you think Roe would have been overturned?
So when you ask me without the idea of originalism, things that I want to put in the bucket of originalism are some of the other things you were alluding to, like Leonard Leo and his entire network, right, that is justifying originalism and providing talking points to support the confirmation of Republican appointees. So when you say without originalism, my mind goes to, well, a world without the Federalist Society, a world without all of this entire apparatus.
I'm not asking without this idea, would we wipe away the people who believed in the idea? I'm saying without the idea, I would assume that Leonard Leo and those who are conservative would want the court to be conservative and find a way for the court to get conservative. I'm saying take away the idea, the vulnerabilities of Roe, that one ruling, not some of the others. Wouldn't they still be there and be motivating to a large percentage of Americans and judges?
So I'm not sure, because I think originalism is both a ideology and a methodology. And I think if you take it away, I don't know what that world looks like as far as them pushing in the executive branch and through nominations for judges who would overrule Roe.
In the book, you write about something that Anthony Kennedy wrote. It seems unexceptional to conclude some women come to regret their choice to abort the infant life they once created and sustained, even though he conceded that there was, quote, no reliable data to back up this take. So I agree, that's sloppy to assert something without data. But to go back to what he says, it's unexceptional to conclude that some women come to regret the choice. You write, and this is a major part of your book, vibes greater than symbol facts. Vibes are better than facts. The facts suggest the opposite is true. So is what you're saying is not true, that some women come to regret their choice to abort the infant life they created and sustained?
So the long-term longitudinal study that Diana Green Foster conducted found that women who are denied abortions regret their choices in that they have lower levels of happiness than women who receive abortions. So I actually do think that statement is inaccurate in the context in which Justice Kennedy represented it, which was a basis to justify restrictions on abortion, because there is no evidence that a woman who is prevented from getting an abortion, right, is made to feel better for having been denied an abortion. And that is the statement that Justice Kennedy is making there, that because some women...
Not. I mean, you're a law professor. That's not what the syllogism said.
That is literally his rationale for upholding the Partial Birth Abortion Act.
The words say it's unexceptionable. The words are the words. I'm mispronouncing them. I'll say it again. Seems unexceptionable to conclude some women come to regret their choice to abort the infant life. I wouldn't call it the infant life, but fine. You changed it to, but what about the women who regret being denied? Possibly a good point, but that's not what he's talking about.
No, so I am not talking about the women who are denied. I am talking about the context in which he is making that statement, which is to justify the conclusion that the federal government can prevent some women from getting an abortion. So it is the disconnect, right, between the statement he is offering as well as what that statement is being used in service of that I think makes the statement horribly false and misleading. Also,
that's not a fact. What you've done is you've taken the implication of his statement and rebutted it. I agree with you, but it's not a fact to say the facts suggest the opposite is true. I mean, this might be a little syntactical, but of course you cannot say that there are facts out there that rebut his idea that it's unexceptionable that some, which I guess could mean 3 or 4 out of the million who get an abortion, come to regret it. There are women, Roe herself, there are women who say they came to regret it.
Yes, although she purportedly rescinded that statement as well. So I don't know exactly my problem is I actually cannot identify anyone. And Diana Green Foster's longitudinal study didn't identify anyone. So if you look at the
Wait, there was a longitudinal study that didn't identify one person who ever said they regret an abortion?
That was her study.
Listen, I can't. Okay, here's how this goes. I'm with you ideologically, but if we're literally asserting that there's not one woman out there,
I'm not going to insert there isn't anyone.
Well, two people to constitute a sum. Then you get to the idea of what facts are. It is not factual to say the opposite of what he's saying is true. It's fine to say his conclusions or that sort of engaging in sloppy logic leads to the terrible conclusion of possibly overturning Roe. I'm with you, but it's not factual to say the opposite of what he said is true.
I think it is factual because I think some is conveying an impression that is just false. And I understand you want me to say like implication or conclusion in service of, but that is not how I wanted to write the book.
No, I just don't. Right. I don't know what I want you to say. I think that facts are stubborn and important things, and that's not a fact. Now, another thing that's not a fact, and this wasn't in the book because it came later, I recently heard you on The Bulwark, and you described Neil Gorsuch yelling in court and pounding a fist at, well, however you said it. He was yelling, he was angry over a book that was introduced in a suburban D.C. school district where a puppy is supposed to look for someone wearing leather. But I went back and I listened to what Gorsuch said, and there was no yelling at all. And, well, first of all, I don't know if you need me to play Gorsuch talking about it.
I cannot remember the verb I used, but Neil Gorsuch's tone was, I would describe as irritated and...
Okay. Corey, could you play Leah's clip on The Bulwark?
Sure. And also apparently Neil Gorsuch, who read Pride Puppy and had an utter fucking meltdown. So he looked at this book, which is a puppy at a
Pride Puppy. Is that like someone in a pup mask at a Pride?
No, it's a little dog at a Pride parade.
Okay.
And teaching kids what you will find at a Pride parade. And Neil Gorsuch looked at this book. There's a woman in a leather jacket. And he was screaming at the top of his lungs at the advocate, why are you letting kids look for bondage and sex workers and BDSM? And the advocate is like, that's a woman in a leather jacket, Neil. So there's that.
Okay. And I don't know, do you want us to play how he actually talked?
I won't say he's screaming at the top of his lungs. He is agitated and getting irritated with the advocate in a way that I often rib him for.
Okay. So I didn't even hear him say that. And the only reason it matters is the book is a collection and the analysis is a collection of real deep, and I think my listeners can understand the depth of your knowledge, but also humor and pop culture, but also hyperbole. And so I wonder, as someone who, since so much of our conversation was about trying to communicate to the public and giving the public a correct impression of what the Supreme Court was doing, I wonder if you worry or fret over using too much hyperbole in describing what the justices are doing, such that people could come away with a real misimpression of the actual nature and decisions of the court.
I don't. I think the picture I have painted of the Supreme Court is describing a fundamental aspect and core way in which the Supreme Court is operating. As we've been talking about, you can always identify exceptions or departures, either in like the vote breakdown or particular cases as to how they are decided. The differences among the Republican appointees, how you might describe, one passage or another, or like the tone or tenor of a separate writing or a statement at oral argument. But I think that the picture I paint of the Supreme Court captures an important reality that I want people to see in the modern court. And honestly, like courts that preceded it as well, because a lot of the book is also identifying origins for what's happening.
Do you think there's a cost? And I think I know what your answer is going to be because I've heard you talking about it. But do you think there's a cost or a danger, especially before the current court, to talk about how illegitimate the Supreme Court has become, to question the legitimacy, given that now the Supreme Court is perhaps the last bulwark to the lawlessness, unconstitutionality, and deep excesses of the Trump administration?
Yeah, so it is, as I think I've said before, kind of a weird time for a book that is focused on the court to come out that is very critical of the court, in part for that reason. But I guess I hold two different ideas in my mind. One is that criticizing the court, urging reforms to the court is always going to be different than saying we should not respect judgments or decisions of the court that enforce a statute against the executive branch or something like that. Like there's conceptual space between these things. Second is, I think it is important to understand the ways in which the court is aligned with the Trump administration and also lay the groundwork for the Trump administration, both with respect to particular substantive areas of law, but also just with respect to the Trump administration, period. So I just think law, politics, ideology, society, a lot going on. It's complicated, but this is an important part of the story that I wanted to be presented. You know, the book is not intended as like an academic tome on all facets of the Supreme Court. It is
most
effort.
academic tomes don't have much Barbie content in them or Game of Thrones.
Or Mean Girls or anything else.
Right. I agree with you. Criticism, scathing criticism, deserved criticism, check, check, and check. But legitimacy, a little bit dangerous. And then actually asserting this court is illegitimate. Not even the whole, this court threatens or flirts with illegitimacy. This court is illegitimate. That is something on the show that I've talked about. I very much am worried about it. And you know that once the court gives a ruling, as they will, that Donald Trump doesn't want to adhere to, he's going to reach for that. He's going to exactly point to those statements, and it's going to be weaponized. And so that's why phrasing or thinking about the court with that specific term, illegitimate, really worries me. Does it worry you?
I understand the concern. I guess it doesn't worry me for two reasons. One is, in some ways, I think it's overdetermined. The court's public approval ratings are so low, especially in the aftermath of them overruling Roe. I think they did a lot of the damage to themselves, and people calling the court illegitimate, that was not, right, like kind of the driver about people's opinion of the court after Dobbs. So that's one thing. Second is, I want to put us in a position where if and when Donald Trump asserts the authority not to abide by a Supreme Court ruling that tries to enforce a guarantee of due process against him or whatnot, that we recognize our collective responsibility to ensure compliance and to call for compliance and to demand the enforcement of the law, and not just to hand it all over to the idea that the Supreme Court is perfect and good and anything it says should be respected. And so for us all to play a role in that kind of like collective constitutional position.
Well, saying the Supreme Court did it to themselves with this one bad ruling, the Supreme Court's favorability rating is, according to Pew, last I looked, 47%, 51 unfavorable. But, you know, the Democratic Party would kill for a 47% approval rating.
They've also done that to themselves, though.
Well, that's the thing. This is what I'm talking about. Then if you say Congress is illegitimate, our institutions are illegitimate. I mean, I don't know. I'm just more
I just think it's so
important
to like recognize institutions are flawed and that like we can improve them.
But does that mean they're illegitimate? Does that mean we should say they're illegitimate? Does that mean our very well listened to podcasts
saying
should
like
engage
the way
in
they're
this?
operating right now is not legitimate. You know, I just think the federal legislature has become
sorry to interrupt, but of course it is legitimate because we have to follow them, just like Trump has to follow them. If we say, damn it, I hate it, but it's legitimate, they're the court, you got to follow the rules, we'd be in much better position.
But when I say illegitimate, I'm
now.
not calling for mass civil disobedience.
No, I know. You're one of your prescriptions is meme the shit out of these guys and Amy, so I know that. What do you think, other than the public getting involved, what do you think can be done? Do you think anything can be done through statute with just a pretty small issue of the justices on the court accepting extremely large gifts from donors?
So I think it can be done by statute. I am not confident that the current Supreme Court thinks it can constitutionally be done by statute, though.
And You don't think this? So are they going to be the final determinant on that?
This is part of the issue. Is I do worry they would say, and we have the power to strike down this statute that attempts to restrict our ability to receive gifts.
And what do you think of the idea of, or the fix of packing the court? Which is to say increasing the numbers, which wouldn't even be a constitutional amendment, would it?
Yeah. So I just think that reform, like any of the reforms, should not happen alone, because I just don't think that is a fix for the problems that have developed with the court.
Leah Litman is a co-host of the Strict Scrutiny podcast and the author now of Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. Thank you very much.
Thank you.